Okay. Hello, everyone. Thank you for joining us for the third session of our 2025 Employment Law BootCamp. The topic today is investigations and terminations. And so we're going to go over some of the potential legal exposure that arises from terminations and what some of the higher risk areas are, and then some of the best practices for investigations. And if you have any questions during today's presentation, we do have a Q&A open, so you can go ahead and type your questions there. I'm happy to take them as we go along. I will be sharing the slides at the end of today's presentation, so you'll receive a copy of those after if you were registered. So we will just go ahead and jump in. Just my disclaimer, I don't think I have it on the slide, but this is legal advice. I can't give specific legal advice on a situation in this context. All we can provide without a lot more detail is just information about the law and some helpful tips and tools to help you spot issues in your own workplace. And now it won't go. Let's see. Oh, sorry, let me just get my Q&A open there. Okay, so won't go. There we go. Okay, so some of the legal pitfalls in terminations are here. It's kind of 8 topics. I don't know if they're all pitfalls, but the first is the concept in California that we have of at-will employment, meaning either the employee or the employer in most situations has a right to end that relationship for any lawful reason. So what comes up then is, was the reason lawful? That can always be called into question based upon the circumstances surrounding the termination. And that arises when you have a legal claim. So even if you have an at-will employee, they could bring a potential legal claim that their termination was not lawful. The opposite side of at-will employment is employees that have an employment agreement for a specified term. Usually those agreements have in them the reasons that the employee could be terminated, for example, for good cause. And then sometimes they provide a severance payment if the employee is terminated without good cause, or other contract terms that govern the end of that relationship. So if your employee has a contract that governs the end of the relationship, then they are not an at-will employee. The disciplinary process, the next part of termination that can go awry or that could cause a problem. We'll talk more about that, but sometimes there is no disciplinary process, or it's not clear, or employees bring claims because they don't feel like they were given sufficient warning or ability to correct their behavior, and whether or not that is required is an issue. But sometimes that does create the problem. And sometimes we get to the end of the termination and there's nothing in writing that evidences the disciplinary process. And so the employee looks stellar on paper, but then clearly they weren't, because there was enough problems that the employer moved forward with the termination. Investigating and documenting complaints can be an issue. And because half of this topic is investigations, we're going to go through that. Communicating with the employee is a lot of times a concern or confusion, or if there's no communication, that can present a problem. What termination paper, sorry, I have an allergy. What termination paperwork is required is an issue, or is there any? Sometimes I get files where the employee was terminated, but there's no termination paperwork. A lot of employers have a question about severance agreements. When should you give them? What should they include? And we're not going to go through the legal requirements of a severance agreement, but we'll talk about them a little bit. And then we're going to touch briefly on reductions in force. So this is the code section that sets forth the at-will employment presumption in California. So it says the employment can be terminated at the will of either party on notice to the other. And employment for a specified term is employment for a period greater than a month. That distinguishes an employment for a fixed term from like a temporary, they're hired for a week. And the presumption in California is meaning that employees don't have to have, or employers don't have to have good cause, for example, to terminate an employee. They can terminate them for any lawful reason. The treatment, the law says that you don't have to be fired for a fair reason. The employer could fire you for something that is a bad business decision. The employee could disagree with the reason for the decision. For example, maybe a manager makes a mistake and they think all of these things that went wrong in the workplace were Susie Smith's fault. And so Susie Smith is fired. Well, if the employer had done a little bit better of a job, or done more investigation or had more information available, they might have realized that it was Bob Jones's fault and Bob Jones should have been fired. But even if that decision was wrong or bad or ill-advised, that doesn't negate the at-will employment. The decision is lawful as long as it doesn't violate one of California's laws against discrimination or retaliation, for example. You can't fire Susie Smith because she's African American, or you can't fire Bob Jones because he's the oldest employee. But other reasons that aren't discriminatory or retaliatory and don't mistreat an employee because of protected activity or protected category, those fall within the at-will employment laws of California. And California's concept with this is that even because you have the right to fire someone, you also have to demote them or to change their position or to cut their pay if they're an at-will employee. Oops, there we go. So when we make the decision to terminate an employee, there's a checklist there are checklists floating around out there. I saw one recently from a staffing agency that I thought was really good. But what you want to do is evaluate, and what I do with my clients is talk about what are the risks of this termination. What does our documentation look like? What do the facts look like? And are there any potential legal claims that could be brought? And what's the strength of those? And that then gives the client information about whether they want to proceed with the termination immediately or maybe take some other steps in the interim. So we look always, is there a breach of contract? If this employee had a contract, does it provide for a termination in this circumstance, or would that breach the contract? We look for not just a breach of a written contract, but was there a breach of an oral agreement or a promise for continued employment? If an employee was just given a promotion and somewhere in that letter it says, we look forward to working with you over the next 3 years on this project, that could potentially create an enforceable with the employee. So you want to look at things like that. Of course, we mentioned this already, but discrimination and retaliation. Is there a protected category that this employee falls into? And a lot of times employers think, oh no, there's no protected category. But everyone in this room probably falls into a protected category. One, everyone has sex or gender. Two, most of us are older employees over the age of 40. Many employees have disabilities, either hidden disabilities or disabilities that have been disclosed to their employees. And then you have your more obvious ones like race, religion, or pregnancy, for example. So if the employee falls into one of those categories, has anything come up relating to those categories? Has the employee made a complaint? Has it been an issue in the workplace? Or is the employee maybe the only one that falls into that category? You want to look into more of that situation and decide if there's legal exposure based on that. Retaliation is another one. Has the protected complaint, or has the employee participated in an investigation, maybe even pertaining to another employee? Is there if the employee has a disability, have we exhausted the interactive process to determine whether an accommodation was possible? Sometimes, despite the best efforts of both the employee and the employer cannot do the job because of a disability that has arisen or has increased or changed. And so sometimes a separation is best in that circumstance, but you want to have completely exhausted that process, probably have sought legal counsel. Another question that comes up often is, has a leave law been violated? Did that employee get all of the notices they were required to for California Family Rights Act or Family Medical Leave Act? We talked about leaves of absence last session, and there's a lot of them. So sick leave, pregnancy leave, disability leave, accommodation leave, the list goes on. You want to make sure that one, the employee hasn't just taken one or just requested one, and two, whether one doesn't apply, that they haven't been offered. And then the last thing that comes up more and more frequently, and this was the topic of our first session, is wage and hour claims. Has this employee been paid correctly? If the employee is terminated and they are disgruntled, more and more commonly, they're going to go to a law firm, turn over their pay stubs, complain about their problem, and get potentially involved in a lawsuit against the company. And so you want to look at, is there exposure relating to this employee? It's a unfortunate circumstance, but a good circumstance to take a look and at least audit that one employee's pay to see if it's correct, because you don't want to terminate someone and have unpaid wages sitting on the table that they didn't receive that they should have. Jumping back to the first category, breach of contract, and going into a little bit more detail, there are this slide talks about good cause for breaching those contracts. So not breaching, it wouldn't be a breach if you had good cause, but what allows you to terminate an employment agreement that's for a fixed term? If the employee willfully doesn't perform their job duties, if they're neglecting their duties, or if they become incapable of performing the job duties. I see a lot of employment agreements that are written that don't account for the employee's disability, for example. And so that's something good to include in those. And the standard that the courts apply when looking at this is a good faith business judgment. Good cause for termination requires good faith by the employer, an adequate investigation, and a reasonable ground for believing the charges against the employee. So these are in a contract sense, and then also in the at-will sense, these steps are going to help you assess any potential liability for moving forward with that termination. Here's the list of, there's more now. I don't have them all listed on here for California because each year we add more. For example, being a witness in a case or being a victim of crime is now covered in California. Should have updated this slide for 2025. But there's just on this list, which is from a couple of years ago, there is a long list of categories that an employee may fall into that potentially could be the basis for a claim of wrongful termination. Oh, and then down at the bottom, a perception of being in one of these categories counts as well. So that comes up a lot in the disability area. So some employers will make an assumption that, oh, because this employee has this disability, necessarily they can't then do these job duties. And so even if that's not true, even if a doctor later certifies that the employee could have done that, that can still be the basis for a discrimination claim. Retaliation can be based on, like we said, an employee engaging in protected activity. And that can include opposing discrimination and harassment, participating in a legal proceeding or a hearing, or requesting benefits, such as even if they aren't entitled to the benefit, if they think they qualify for FMLA leave and they request FMLA leave, and then 3 days later they are fired, that is a close enough connection in time that it could be evidence in support of wrongful termination. Also complaining about a violation of the law, and that can be under the labor code for wages or any other type of law like the Fair Employment and Housing Act. So complaining that another employee was discriminated against because of their age, for example. And like I said, the employee can be wrong. They can be inquiring about something or demanding something that they're not entitled to. And the standard is whether they had a reasonable belief. They can't just make something up knowing full well it doesn't apply to them and be protected for that activity. But if they have a reasonable belief, then they're protected. The other thing we look at often is how are similarly situated employees treated. So if you have an employee in a protected class or who's made a protected complaint, are they being treated the same as the rest of their employees? If all of the employees are being treated the same, or they all feel that they're being treated badly, for example, that's one way to overcome a retaliation or discrimination claim, because it's not unlawful to run your business badly. It's not unlawful to not care about employee morale or to have an unpleasant business environment or to have a mean supervisor. So if everyone is being treated the same, often employees go to employment lawyers and say, hey, I'm being retaliated against because my supervisor just is mean to everyone. And that's not going to be enough to give rise to a claim that's valid. And then for retaliation, a little bit different from discrimination, the employer has to have a motive to retaliate against the employee. So this could be statements that are made complaining that the employee, if you're always complaining, you're never happy, you need to mind your own business and stop worrying about Bob. Those kind of statements could indicate that the employee is being terminated because of a retaliatory motive. And the timing comes into this because, of course, like I said in the last example, if someone is complaining and then 2 days later they're fired, there's a presumption or suspicion that it is a retaliatory motive. When we talk about failure to accommodate, I've done whole webinars on accommodations for employees with disabilities. We could spend more than an hour on just that topic alone. But we look at some necessary elements and key questions. Is the job duty that the employee needs to perform and can't perform essential to the job? There's a legal standard for what that is. It has to be one of the core responsibilities. And then, is the requested accommodation an undue hardship on the employer? And whether it's an undue hardship depends on a lot of different factors. The impact of the accommodation on other employees, the impact of the accommodation on operations, the financial implications of the accommodation, whether you can still serve your customers. A lot of that depends on the employee's role and the structure of the company overall. So it's not a black and white test. Before you move forward with a termination, for someone that has requested an accommodation, you really want to make sure you have all of your documentation in order as to why you decided not to allow that employee to continue working with the requested accommodation. Wage and hour claims. I won't spend too long on this because we did a whole session on it. But misclassification as an exempt employee, that's something we always want to look at. The timing of the employee's pay, were they paid properly every 2 weeks or 1 week, depending on the industry? Was there any late pay? Are they receiving their final pay on time? When you make a decision about a termination, if you're the one that terminates the employee, their pay is due immediately. And a lot of times this situation arises where the payroll company can't cut a check instantly. And so that termination needs to be delayed so that the employee is receiving their final pay at the time that they are removed from the payroll. You want to make sure your wage statements are complete and correct. that you've been paying all of the rates of pay correctly, that you've been paying all of the types of pay that are due, that the employee was taking their meal and rest periods, final pay obligations we just talked about, and I have meal and rest periods twice. They do come up a lot. Maybe that's why they're on their double. So one of the questions it's not a legal question, but one of the questions that prompts a lot of the information that does give us an ability to make a legal assessment when we're talking about the disciplinary process that's occurred is, would a reasonable employee in this employee's position have been surprised that they're being terminated? And that often gives me a lot of information to assess. It's definitely a case-by-case determination. Generally, when you get to the end of a case, jurors don't like to see that someone was suddenly surprised with the termination. That feels suspicious to them and unfair. And so for that reason alone, if possible, we'd like the employee not to be surprised. But in a lot of cases, if an employee has been warned and given a chance to improve and hasn't improved, that also means that you have documentation of a legitimate business reason for the termination. If I review all of the documents and there's no indication of what this employee was doing wrong, in a lot of cases, that means that there isn't good evidence of the problems that had arisen. And so it leaves open the door for someone to speculate on why was the employee terminated. And the employee and their attorney and the jurors could say, oh, I think it was because of race discrimination, because of the surrounding circumstances. So you want to be sure that your documentation shows what was really going on in the workplace that led to this decision. And those things, if you connect them back to the position and the job duties and the job expectations, will be evidence of the non-discriminatory or non-retaliatory basis for the decision. So it's case by case, like I said. Progressive discipline is one way to do this. We could talk a long time about the pros and cons of progressive. Actually, I think I have a slide next on progressive discipline. It really depends on the type of workplace. But that progressive discipline, what I mean when I say that is that you have a fixed structure that you process employees through for most disciplinary issues. So first we start with an oral warning. Then we move to an oral warning documented in the file. Then we move to a written warning. Then we move to a termination. So some companies have a very structured process for that, and they follow it. If you diverge from it, then that creates other problems. Not in a case in which you are very straightforward. If an employee embezzles, you don't have to go through the progressive discipline process. If they assault another employee, you don't have to go through the progressive discipline process in most cases, because something, giant jumped in the way of that process and was severe enough to warrant immediate termination. But most terminations are more nuanced than that. Performance improvement plans are something that employers do a lot. They create oftentimes good documentation and at least track kind of what are the goals the employee is expected to meet and have they been met. Unfortunately, a lot of times I see them not filled out very well, or the box is just kind of checked and then no follow-up. So if you're using that process, you want to use it fully. And then most employers are constantly engaging in performance coaching. They don't always document it though. So even emails tracking the performance coaching and following up on what was discussed in a meeting, even absent a formal improvement plan, does create that documentation of why an employee was terminated. Here's some pros and cons of progressive discipline. Clear explanations of consequences, opportunity for consistency and fairness, an opportunity for the employee to change behaviors, an opportunity for the employer to explain, coach, and mentor, clear alternatives for minor infractions. It can improve employee morale when used appropriately, and it can create evidence that the employee had an opportunity to improve. You weren't out to get this employee necessarily, but they just couldn't do the job in the way you needed it done. On the other side, these can be inflexible depending on how you implement them. So particularly very specific written disciplinary, progressive discipline policies, they don't fit every situation necessarily. Sometimes there's a reason that you may want to add more steps in there or give the employee more chances or make some changes. And when you deviate from a strict written policy, that creates another opportunity for that employee or other employees to say, hey, I wasn't being treated the same as everyone else. That's what I just said on my next bullet point. And then also we talked about this implied contract concept, where if you have in writing what you're going to do for an employee or with an employee, and then you diverge from that, there is a potential argument in certain circumstances that you agreed and there was an enforceable agreement to go through those steps. The other thing about progressive discipline and a strictly followed version of that is that small employers, it's less applicable because if you have only 4 or 5 employees, it's very easy to take a very detailed approach to each employee, and there isn't a big precedent. You're not trying to implement this exact same process over hundreds of employees. And so sometimes that makes it less applicable in a very small situation. Do we have any questions on, one second. Do we have any questions on what I've covered so far in terms of discrimination and retaliation and evaluating different issues involving employees when you're making the decision about whether to terminate? Okay, let me go on to the next step then, which is investigating and documenting. So we kind of skipped over a big part that's applicable for business owners and human resources professionals, which is, was the person doing their job to begin with? That's less of a legal question and more of a business operations question. You're the one that knows in your business whether this employee is getting along with others, whether the employee is following instructions, whether they are able to do their job in the way it needs to be done. And so we won't be talking about those kind of things today and rules of conduct. But jumping ahead over that, if you have complaints about employees, in a lot of instances, the law requires them to be investigated. So if the employee complains that they were discriminated against, retaliated against, harassed, all of those legally are required to be investigated. And so you want to document that investigation. The first step that I don't even have on this slide is decide who is going to do the investigation. A lot of times human resources is an appropriate person to do that investigation. They're trained to do that, and they are neutral. They're not functioning in the department with the complainant. If the complaint is about human resources or the complaint is about the CEO, for example, then the question becomes, can that person be neutral? Are they the right person to conduct the investigation? And so sometimes you want to hire an outside third party to do that investigation so that it can really be a neutral investigation and complete without there being any bias or pressure for the investigation to come out one way or the other. But if you are conducting the investigation, the first step is to create a plan. So you want to identify the issues to be investigated. You could investigate all day long everything and every grievance that employees had in a particular company. And that's not what you want to do. You want to be more focused in most circumstances. So if the complaint is about sexual harassment, then you want to have your issue identified. I'm going to investigate this complaint for sexual harassment against this individual. If the complaint is that hiring in a particular department is being done in a discriminatory way, then that would be the scope of your investigation. So based upon the specific issue you're investigating, you want to develop your witness list. You want to identify the sources for information and evidence, and you want to identify any documentary evidence. So this would include whether there's personnel files that should be reviewed, if supervisors maintain files, are there training files, are there witnesses both in the company or outside the company, such as a vendor or an independent contractor that may have observed what was happening. And then are there any videos, recordings, anything like that, photos that may be applicable. So all of that is going to go into your plan for the investigation, and then you can go ahead and start preparing for your interviews. So the second phase of this is that you want to be an impartial and an objective fact finder. You're going to consider relevant facts and focus on the allegations in the complaint that were made, or within the scope of the investigation that you've decided on. An employee often comes and says, oh, I'm complaining about X, Y, and Z. They don't put it in legal terms. They don't focus on just the sexual harassment issue. They feel just unfairness in general. And so you want to hone in on the specific grievances that they have or the specific things that you are investigating. When in preparing for the interview, it's hard not to speculate or to reach gratuitous conclusions that make common sense to you. But the goal is to try and focus on the facts as much as possible. When you're interviewing the individuals, you don't want to do anything to offer your own opinion or to discredit your impartiality. So the person doing the investigation shouldn't have been involved in the underlying issues in most instances, because that inserts them as a witness into the facts that are being investigated. But the investigator's opinions should be saved for their conclusions at the end rather than offering them to the employee. Sometimes it is hard not to sympathize with the person who's speaking to you and being upset, but you really want to put on your investigator hat for that purpose. You want to look for inconsistencies and seek opportunities for more evidence and other witnesses as you're asking the questions. So you start with your initial list of documents, and as employees bring things up, you're going to want to add those and make sure to obtain them. Employees often say, oh, well, that was captured in a series of text messages, or, oh, I saw a Facebook post that supports this employee's position. And so you want to add those things to your list and obtain a copy. A lot of times I receive investigations that have been completed, and maybe there's notations about the reason the employees felt a certain way, but those documents weren't captured and saved into the file, and sometimes they're no longer available. So if you're doing an investigation, you want to get copies of all of that and include it in your file. One question that comes up a lot in investigations is, should I always ask the employee to write a written statement? And there's no legal requirement that a written statement be obtained every time. Some employees won't write a written statement. And so that means you don't have it available. But that doesn't mean that what they told you wasn't evidence in and of itself. So if you're not going to write down what happened, you need to have notes about if you're not going to have the employee write down their side of the story, you need to take notes on what they said, because that will become the evidence. And a lot of times there's a benefit to having the employee write down what they observed, because it forces them to think really hard about their version of the story and what they recalled, because that then doesn't change. That's now written down as the first rendition. And it can identify some inconsistencies in their story as well, either as they're going through it or when you ask them questions about it later. The employees will all have different versions of the event. And it's suspicious, in fact, when they all say the exact same thing, because our memories are not that good. Employees forget things, they remember them wrong, and they're viewing everything from their own perspective. So each witness's story is necessarily going to be slightly different and can be wildly different, even if each individual is telling their version of the truth. So your job as an investigator is to make a credibility determination regarding divergent stories. So you do need to gather facts that are going to allow you to assess the plausibility of the employee's story. If they say it happened on the 9th and they're absolutely certain it happened on the 9th, and the 9th was a holiday and no one was at work, either they have the date wrong or they are not telling the truth. So if it's plausible or not is a question. I don't know what I meant by ability. The witness's demeanor plays into that. So it's good to take notes about their demeanor. If they're being really shifty or they're being resistant to answering questions, and you notice that, write that down in your. Do they have a motive to lie? Are they best friends with the person that made the complaint, and they have a reason not to tell the truth? Is there a motive to falsify information? Perhaps they are worried that they're going to get in trouble. Do multiple witnesses corroborate the same set of facts? Does their past behavior evidence any motive to lie or create a trend that would be applicable to determining credibility? And have there been past accusations? Have others complained that this person harassed other people? Have there been accusations that this witness lied in the past? All of that, even though not directly about the facts you're investigating, allows you to evaluate credibility and should be noted down if it's relevant. You want to keep an open mind and be prepared to complete any necessary investigation if new facts arise. So if an employee complains, for example, that they are being bullied by a particular supervisor, and you interview another employee that says, oh, I was also bullied, well, that wasn't part of your original scope. But if you're evaluating whether this employee engaged in wrongful conduct, wrongful bullying conduct, then it might be appropriate to expand this investigation to cover it. Sometimes if you hear, oh, this employee embezzled when you're doing a harassment investigation, that's a separate investigation that should be open, doesn't need to be included in this one. That's why your topic is so important. Maintain good notes throughout the process and create an investigation file that is kept separate from the employee files. You do not need to include your investigation in that employee's file. That is a separate business document that belongs to the business. Employees can request their personnel files, and those should include documents that they have signed pertaining to their employment, like offer letters, performance evaluations, and other similar documents relating to job duties. But your investigation does not need to be in the employee's file. If you give the employee a letter about the conclusion of the investigation, that could be something that goes in their personnel file, but you want to keep this work product separate from the employee's file. And you want to maintain your investigation confidential while it's being conducted. So when you're conducting your interviews, there's some things that you should tell the employees that you're interviewing. You have to give them some background on what is being investigated. You don't have to tell them the names of all of the people involved necessarily, but you have to give them enough information for them to know what you're talking about and for them to be able to tell you if they observed anything related. You should explain to them that no conclusion is going to be made until all of the facts have been gathered and analyzed. You should advise them that the investigation will not result in any retaliation against anyone who participates, but providing false information or refusing to participate in the investigation could result in discipline or corrective action. While employees are employed with you, they can be required to participate in the investigative process because that's essentially one of their job duties, and it allows you to implement your business in a lawful manner. And you want to, I always add this, it's kind of a separate thing, but ask open-ended questions. If you ask only, did you see Bob touch Susie's shoulder? The answer may be no. But did you see Bob touch Susie ever in the workplace? Or did you see Bob touch any employees? Or did you see Susie uncomfortable in any situations with Bob? Those are more open-ended questions and might gather information that you weren't aware of when you began. Information generally that you want to gather is the employee's observations, what they see or hear or read that would be relevant to the subject you're investigating. Do they know of any other witnesses that are relevant? Every witness should be asked if they know of any other witnesses. Do they know of any documentary evidence? Like I said, text messages, Facebook posts, letters, emails. And then are there other related incidents or issues to the subject? So sometimes at the end, you want to ask an open-ended question. Are you aware of any other, any information I should know that I haven't asked about that pertains to this subject? At the end of the investigation, you do not want to reach a legal conclusion as the investigator for the company. The legal conclusion is going to be left up to a jury at the end of the case if there's a lawsuit. You want to reach only factual conclusions. I've had a few cases in which the investigation said this employee was harassed. Whether they were harassed is a legal question. Did it meet all of the legal requirements? Is it harassment under the law compared to other legal cases or judicial opinions? Your conclusion should be, relating to Susie's complaint. So if Susie said he kept touching my shoulder in the hallway, he asked me out on multiple dates, he kept texting me after work, did those specific things happen? And you can investigate each of the things that bothered Susie and say, did it happen or did it not happen? So you could substantiate Susie's allegations and complaint. You could find her complaint to be unsubstantiated if the evidence does not support it and you don't think it happened. Or sometimes there just isn't sufficient evidence to reach a conclusion, and you can say that as well. So rather than finding that there was harassment, you can instead find that these things were substantiated, unsubstantiated, or that there's insufficient evidence to reach a conclusion. You're going to report the findings to the decision maker, who's then going to reach a conclusion about what action should be taken. So that's going to involve a variety of things, not necessarily legal conclusions. So if the actions taken by the alleged harasser violated your policies, even if they didn't violate the law, there may be a decision to discipline, terminate, retrain. So that's going to be up to the supervisor or decision maker based on the investigation results. Even if something isn't illegal, for example, bullying is not illegal. We have to train on it, but it's not an actionable course of conduct, but doesn't mean that you want it happening in your business or that it doesn't present other negative consequences that you want to avoid. You could elect to terminate someone for being a bully, even if that doesn't mean that there's a legal claim that could be brought against that individual. You want to notify the complaining employee and the accused employee that the investigation has concluded. This is a common source of unhappiness, is that the employee makes a complaint, they aren't kept apprised of the status of the investigation, and then they aren't told the outcome. Now, what you tell them about the outcome is limited by employee rights to privacy. So obviously, if you terminate an employee and they're no longer at the company, employees are going to assume that they're no longer there because of the investigation. There's nothing you can do about that because it's just their observation. But you cannot provide specific information to a complaining employee about discipline that happened to other employees. So if you send an employee back to sexual harassment training, but you keep them on because maybe their conduct didn't violate your policy or wasn't so severe that you want to fire them, but you decide to retrain them and maybe you give them a few days off without pay as punishment. That shouldn't be disclosed to the complaining employee. You can tell them that you substantiated their allegations. You can tell them that you took corrective action. And you can tell them that if something comes up again, they should reach out to you and that there won't be retaliation, of course. But what specifically was imposed on other employees does come within California's privacy rights. And if the investigation could be reviewed by a court because there is a sexual harassment lawsuit filed, consider preparing a final investigative report that would be potentially given over in that lawsuit in the discovery process to the other side to show the steps that the company took. One, prevent any harassment or discrimination, and two, to take appropriate corrective action. Jumping back, if you decide to terminate an employee after you've done an investigation into their conduct, or if you decide to terminate an employee because, well, you know what, 1 second, because I think I'm jumping. Let me look at my slides. I think we moved back here into I'm done with the investigation section. Do you have any questions about conducting investigations and the items that are, in my opinion, keep in mind while you are doing them? Does anyone have any questions on that section? I got off of my Q&A. Oh, I do have a question. If you decide to hire an outside person to do the investigation, is there a time frame that the investigation should be completed by? I know this is a tricky one because investigators can be really slow. And that's one of the things I ask when hiring an investigator is, when can you conduct this investigation and do you have time to complete it quickly? Because investigations under California law have to be done promptly and appropriately. And so if it takes 3 months to conduct an investigation and get a report, and the employees are in limbo during that time period, then that presents a significant problem. So when hiring an outside investigator, that's one of the things you want to ask. There is no outside time limit on how long an investigation can take. There's no bright line rule, but depending on the severity of the allegations and what you have put in place to address the situation while the investigation is occurring, that affects the employee. So If it's a harassment complaint, a lot of times we remove the harasser or alleged harasser from the workplace and allow the employee who complained to continue working. That person might be home without pay. But if they're ultimately found to be, the allegations are found to be not substantiated and they had to be without pay and without the ability to do their job for a long period of time, they could have a potential claim for that. And you want to be able to take prompt remedial action as well. So sooner is better in every respect with regard to an investigation. Some investigations are large and very complex. If it's looking at how an entire department is run, that's not going to happen in 2 weeks. But if your investigation takes longer, you need to evaluate what you could do in the workplace to make it satisfactory to the employees and safe for the employees while the investigation is ongoing. I don't know if that answered your question, but it's hard to answer. Most investigations can be done within a few weeks if the investigator has time to take it on. Okay, so jumping back to the next slide, you've decided to terminate employee, either because of poor performance, because of, which could include interpersonal issues, subordination, whatever you've decided they are not meeting expectations, or because you concluded an investigation and decided that they had done something that violated your policies. So you want to communicate with the employee a clear and concise reason for the termination. We used to, and hardly ever give reasons for a termination. We're going in a different direction. We're ending the employment relationship because you're an at-will employee. Have a nice day. Here's your final pay. With the expansion of litigation, I see a lot more employers wanting to provide a specific reason for the termination. Sometimes that's really easy to do. You stole money from the company, so we are firing you. Put that in the letter. If that's the reason, it's very straightforward. Put that in the letter so that when they go to a lawyer and say, I was wrongfully terminated, there is at least some evidence at the outset as to the reason that you made the decision. If they are not getting along with other people, or they are kind of not doing their job right, or it's a much more nuanced situation, it's harder to provide a clear and concise reason. So you do, if you've had an ongoing disciplinary process with them or an ongoing coaching process with them, it shouldn't be a surprise. You could refer back to the 3 months of coaching and that they still aren't meeting expectations. That could be your concise reason. But in any event, whatever it is you decide to tell the employee, you don't want to argue with them in that termination meeting. Once you've made your decision, the process for arguing with the employee and hearing them out has already happened. And so you want to let the employee know that the decision has been made at that point. Once you've prepared that final check, you want to have already gone through that process. You want to have all of your paperwork prepared at the time of the termination meeting, their final check, all of those required state forms, anything else that you need them to fill out or that you need to provide to them. If you are providing COBRA documentation, for example, that has to be prepared and given to them at the termination meeting. I like to also do a breakdown of the final paycheck so they can see what's going into it and what the parts are, what their vacation balance was, for example. Oftentimes you want a witness there. I mean, almost always, I prefer there to be a witness there during the termination meeting. You want to send documents certified mail if the employee can't come in. The obligation under the law is to provide the final paycheck at the time of the meeting, which means that it's not direct deposit. Direct deposit is considered to be terminated at the time the employee is terminated. So their final pay shouldn't come via direct deposit. It should be in the form of a check. Your obligation is to make that check available at their workplace. And so if the employee wants their final check mailed and their final documents mailed, you can get them to confirm that in writing, give you the address that they want it sent to, and you can send that. Always send it certified, however, because you want to be able to track that they arrived and were received. In very rare circumstances, employees refuse to pick up their checks or don't consent to them being mailed, or they come back undeliverable. In that situation, you can turn the documents over to the state unclaimed property fund. There's a process for doing that. Sorry, not the documents, the check. Termination paperwork includes the final paycheck and an acknowledgement of that. A lot of times the employees refuse to sign. That's okay. Just note down that they refused to sign and have someone initial that the documents were provided. State handouts, you have to give them a notice of the change in relationship. Any benefits termination paperwork, a lot of benefits, the broker or the benefits company provides this, so you don't have to, but know whether or not that's the case. A termination letter is often helpful, saying today is your last day, and it lays out then you're going to be hearing from the medical insurance with your COBRA letter. You received these items today, and this is the reason for the termination. You don't always have to give a termination letter, but sometimes it can be helpful as a cover letter for the rest of the packet. You have to give, there's a couple state handouts, the About Your Benefits pamphlet, and I can't remember off my head the others. And you have to notify the benefits and the state that the employee has been severed from the employment. The question about the final paycheck, does it have to be in hand if you're terminating the employee? Yes. The final paycheck is due at the time of termination if the employer severs the relationship. If the employee quits and they give you 72 hours, you have 72 hours to prepare their paperwork. So if they give you 2 weeks notice or a week's notice, you just have to have that check ready by the end of their notice period if you're going to let them keep working through the end. But if you're doing the termination, the employee has to receive that check at the time of termination. So if you can't get a payroll check and you don't want them to continue to be at the workplace, one option is to front date their termination. So you could say you're being terminated effective tomorrow. We're going to have your check available, come back in, but now you can go home, you're off work, come back for your paperwork tomorrow. That's not ideal, but that is one option when payroll simply can't get the check ready. I have more comments, 1 second. You can't hear me anymore. I don't know what to do about that. Hopefully you can still hear me. I'll try and speak louder. Can we mail the final check instead? Technically, no. The labor code doesn't provide for that. It has to be made available at the workplace. But as a practical matter, employers do mail the check. And then it's best, though, if you mail the check, to have the employee acknowledge either in text message or email that they want it mailed. Then that would allow you to mail it. Any other questions about that? Oh, I ran out of time. Okay, it's 1. Severance agreements, just briefly. You can offer a severance agreement. Employees have to have specific amounts of time under the law to review that and to sign it. So the process is you issue final pay, you issue the vacation wages owed, you do the final termination paperwork, you provide them with a severance agreement, they consider it, and then when they bring it back signed, that's when they get their severance check. If they want to sign it right then, if they're not an older employee, that's okay. because there's no waiting period. But it's separate from the final pay. They get the final pay regardless of whether they sign the severance agreement or not. And then reductions in force we won't go through, but if you're laying off a number of people, here I have the numbers, you have to provide notices in advance in California. So I just wanted to note that for those of you doing layoffs. The question is, what if an employee refuses or makes excuses to come meet with you for the termination? Can you do it over the phone and then mail the final check? That's what a lot of employers do. This is kind of an outdated portion of the labor code because you run into this situation. Most employers that I work with do choose to mail the final check, certified mail, whether or not the employee puts it in writing, because their preference is to not sit there holding it in their office indefinitely, but to get it to the employee. And then ultimately, usually the employee does deposit it, and so it becomes a non-issue. Legally, specifically, it says it has to be made available at the workplace. I suppose you could mail it and still have it available at the workplace. And if the employee deposits it, then you've still met both requirements. I hadn't considered that before. We also email employees copies of termination documents so that they have them, because the objective is to get the information that's necessary into the employee's hands, whether they want to come get it or not. That was the last slide. Does anyone have any questions from any of the presentation today? Please let me know in the Q&A. I'll stay for a few more minutes. If you have follow-up questions that you want to ask on the topics covered today, you are welcome to email me, and I can follow up on those with you. I will send out the slides after today's presentation. I did realize as I was sitting down to do today's presentation that I didn't email last week's slides. So I'm going to be sending out both if you attended both. And then all of these presentations are going up on our website. I sent links, and I know some people were having trouble viewing the videos. So they should be available just by clicking on the video section of our website. So I'll send a link to that as well. Once all of the videos are up, I expect that to be by the end of next week. Okay, I don't see any other questions, so I will go ahead and sign off. Thank you for attending the boot camps. I hope they were helpful. Oh, one thing I wanted to add. If you have other topics that you wish I had covered or that you want me to cover, I would like to do more webinars more often. And I will be doing the boot camp again next year. So please feel free to send me any topics that you wish that I would cover in a subsequent webinar. Okay, thank you, everyone. Have a great day and a good weekend.